Hi, I'm Ian Smith with fedsmith.com, and today we're taking a closer look at a new rule from the Office of Personnel Management that affects federal employees at the Department of Veterans Affairs. On July 25th, OPM issued a final rule in the Federal Register, set to go into effect on August 25th, 2025, that outlines how VA employees, both current and former, can appeal decisions to recoup financial awards, bonuses, and relocation expenses. This rule stems from the VA Accountability and Whistleblower Protection Act of 2017, which gave the VA secretary authority to claw back payments if misconduct, poor performance, fraud, or malfeasance is discovered after the fact. Here's what federal employees need to know. If the VA determines that an award or bonus was paid in error, perhaps due to misconduct that wasn't known at the time, they can issue a recoupment order. The same applies to relocation expenses that were authorized based on fraudulent actions. Before issuing a final order, the VA must notify the employee and give him or her 10 business days to respond. This is the employee's opportunity to provide context or challenge the proposed recoupment. If the VA proceeds with the order, the employee can appeal to the director of OPM. That appeal must be submitted in writing within 7 business days and include key documents such as the original order, the employee's response, and a written explanation of why the order is incorrect. OPM will then review the appeal based solely on the written record. They'll issue a decision within 30 business days, and that decision is final. There's no further administrative review from within OPM. It's important to note that OPM won't revisit the underlying disciplinary action. Their role is limited to reviewing whether the VA followed proper procedures in issuing the recoupment order. So, if an employee wants to challenge the facts of the misconduct itself, they'll need to pursue other legal avenues. Also, the rule doesn't specify whether judicial review is available. OPM won't include an appeal rights statement with its decision, so employees may need to consult legal counsel if they're considering further action. The burden of proof lies with the employee. You must show that your appeal is timely and that the VA's order was issued in error. If you miss a deadline or fail to provide the required information, OPM may hold the VA's decision by default. So, what's the takeaway? This rule provides a structured framework for appeals, but it also places a heavy responsibility on employees to act quickly and thoroughly. If you're facing a recoupment order, it's essential to understand your rights, gather documentation, and respond within the required timeframes. To read the full article on this and see the specific provisions, head over to fedsmith.com. I'll include a link in the description below. Thanks for listening, and if you found this helpful, please consider subscribing for more updates on current events that impact federal employees.